very much for joining us today in relation to our mediation webinar. Quite close to the beginning of lockdown, which now seems like several decades ago, the three of us ran a webinar about remote mediations and also remote species of other types of ADR. And what we wanted to do was to update that with a view to sharing with you some of our experiences of conducting remote mediations, some of the pitfalls, some of the great advantages we think in doing it that way. And we really want to take you through the journey of the mediation, starting with how you decide what sort of mediation to undertake. Now, during lockdown, there have been all sorts of mediations taking place. Some have taken place in real life with plastic screens and hand sanitizer, lunch and coffee arriving in small cardboard boxes. There have also been remote mediations, which is going to be the subject of what we're going to talk about most today. But there have also been hybrid mediations, for example, where the solicitors, counsel and client might be in the same room together, whereas the mediator is remote and the other parties are in perhaps a separate location altogether. And it's certainly my experience that those hybrid mediations have really worked rather well. One of the things I find that you lose in a remote mediation sometimes is the ability to sit in the same room with your client and perhaps really engage with them at crucial points of a mediation. But I'm interested to know in what Miranda and Barbara think about that. So Miranda, what has your experience been in relation to that?
I think it's very much to do with the vulnerability, perhaps, of the lay client, not only, as it were, from the physical perspective, but also from the emotional perspective. And when we were in very hermetically sealed lockdown, I was finding that it was important to make sure that there was a member of the same household who absolutely, in a sense, was to be seen and therefore seen by myself as being able to give emotional support. So I think in all these things, the really important thing is thinking through how far also the mediator is going to be able to connect with the important people in the room. And physically, sometimes one of the problems is in the hybrid is that you have to have everybody hunched over at their screen in order to be seen. And what the mediator misses, which might be quite an important thing to miss, is that if the lay client is centre stage, one can't see the grimace on the face of the lawyers about a particular aspect of how the mediator is dealing with everything. So I think in all these things, it's just determining what is the best form you're going to get in terms of engagement in the process for everybody.
What about you, Barbara?
Well, I really agree with what Miranda said, and I think obviously absence of true face-to-face contact is an issue, and I do, as part of my pre-mediation guidance that I try to offer people, is the importance of being comfortable, and that's both having a tech setup that is reliable, lots of points on that, being in the place where, preferably where your router comes into the house, and being aware of how bandwidth hungry video streaming is. You also need your device on a fast charger. I video stream on my laptop, and I've had it on a non-fast charger, and it's been sort of going down alarmingly. So tech stuff like that, but also I tell people to be comfortable and to dress comfortably, and saying that for some people, dressing comfortably for what is essentially a business meeting might mean conventional business wear. And I have had solicitors in suits and ties. They're the only ties I've seen anywhere, and I've been on the tube a lot in London during lockdown, no ties. But it's a matter of personal choice, and I think for the non-lawyer participants. Obviously, well, frankly, I wouldn't know if they were in their pyjamas, certainly not the bottom half, but obviously not something so informal you don't need to be seen by your family. But I do think the sense of comfort, seating, lighting, tech connection, what you wear, having food and drink available, it's important as a way of mitigating the not being able to shake hands and look people straight in the eyes.
Because I think Barbara actually arrives at a very important point when she talks about the food and drink, etc. Because if you are doing the hybrid, you at the moment are likely to be in a really rather depressing, empty environment of a solicitor's office, or perhaps the outer reaches of a hotel where you've been banished to. And actually, it can become quite a physical ordeal, the duration of the day, unless you have looked at those very practical arrangements very carefully.
Now, you've touched, both of you, on a really important issue, which is preparation for a mediation. Now, that's always important, whether it's going to take place remotely or it's going to take place in real life. And I know that my bugbear in terms of preparation is when the parties haven't really thought, for example, about the tax implications of any deal that might happen, and that just simply prevents a deal being done on the day. But obviously, if you're going to conduct a remote mediation, there are other considerations that have to be taken into account. Barbara's already mentioned the technical side of things, and obviously that is crucially important. Miranda, have you reached any conclusions about the tech and how that has to work to make a successful day?
I think where you are going to do close figure work, and particularly in a sense, if you're looking, say you're looking at estate accounts, if you've got an Inheritance Act claim, you're going to be looking at issues of maintenance. And I think the reality is that the online does make the figure work actually slightly more difficult than it is if you're physically looking at bits of paper. Not only, as it were, the exchange between the parties, but actually for the lay party, I think it's much more destabilizing than we professionals perhaps realize, that if you say, oh, well, I've just lost £50,000 here, or I've added it there, and they're in a virtual room without that before them, it's more difficult for them to absorb without being worried about whether all the calculations underpinning it are being demolished. You also have to think about whether or not you're going to need your private client department potentially to have the link. Because actually what I have found sometimes is that it's quite helpful having the private client department come into a room who prepared the estate accounts, able to say to everybody, well, this is how I've arrived at it, rather than half a dozen phone calls round the various individuals. And so that's something that needs thinking about in the setting up. And perhaps before I embarked upon a little bit of close figure work and my own particular hobby horse, I was just going to perhaps ask to go back to Barbara to deal with what we all have been doing, which is these sort of pre-mediation sessions and the value that we think they are adding to the setting up, and what we actually might take away from them for when we're back in our physical world, because I know that's something that Barbara's worked on very hard.
Yes, Barbara, what do you say about that?
For me, the worst moment of a virtual mediation is the very beginning. It's when you click the join button on Zoom. Now, I've done a number of virtual mediations now. I've used Zoom extensively for video conferencing professionally. I have regular video conference calls with friends and family as well, like lots of people. It's become part of the furniture of our lives. But still, there's an awful moment of, will everybody be there? Will they be in the right places? Will they be struggling with something or other? Anybody who knows me knows first thing in the morning isn't my best time of day anyway. It's hugely stressful. And so I've been thinking quite hard about techniques for mitigating that stress. One is to send people guidance beforehand. Another is reassurance, always making sure that if people are struggling, they've got a line of communication. Jo, our receptionist, has been fantastic support to all of us with all of our online work during lockdown, and she's immensely reliable and knowledgeable. She isn't always available. She's also our receptionist. She might be on another call. So it's very important for me to make sure everyone can contact me by landline or mobile phone or email or however is most convenient for them, but they don't feel stranded right at the outset. I think that's really important. And also, I'm a huge fan of the entirely separate pre-mediation meeting, and that's with party by party, not together, half an hour or so. And in fact, really, that's half an hour out of time that would otherwise be spent at the mediation. It's the introductions, pleasantries. I had one earlier this week for a mediation I'm doing next week. I haven't read the bundle yet. When I first spoke to this particular party, I have a rough idea. Obviously, I know the case has something to do with somebody's inheritance. That was it, and I asked just for a 2-line summary in their own words. But it's a real icebreaker, and actually, flipping over to the social side of Zoom, I'm somebody who hates Zoom parties. I don't mind a Zoom call with three or four people, but I discovered very early on I hate Zoom parties because frankly, it's no fun faffing around with a gin and tonic in your own kitchen talking to people. But also, you can't have an icebreaker conversation with somebody you don't know or don't know very well, which is just not possible. And I think these icebreaker conversations are important in mediation. You have to gain the confidence of the participants that you are there to do the job you've been asked to do and can do it. And actually having a not on the day, face-to-face on the screen, I think is absolutely excellent. And it means they can also ask, they can be reassured the tech works, that they've seen your face, they've heard your voice, and they can ask any questions that they have. And even without having read the papers, it might flag up some area of prep or thinking that one can plant seeds. Because again, a very big aspect of mediation is the real work that goes on. It's the change of heart, the change of mind. And that's the client's change of heart and change of mind, not the lawyers. Lawyers are used to being flexible and familiar with negotiation and familiar with the case. We do that. That's part of our trained skill set, but it isn't for the clients. And of course, the subject matter is much more important to the client than it is to anyone else.
Yeah.
And that is what it takes up an awful lot of time what accounts for what has really happened between 10 in the morning and midnight or whatever is that change of heart or change of mind. If you can start planting the seeds, if you can start at least planting the seed of the idea that they will be doing some of that, get them thinking about it. I think, well, I'll see, but I think that can help.
Yeah, and I think really that is then going to be something that I will take away from doing the virtual back to the physical world.
Absolutely, every time.
And offer it as a facility as we go forward and hopefully are able to meet again.
Yes.
As something that will, I think, move people on, and one hopes that for the lay parties for whom ideally this is their only ever experience of mediation, certainly in something that's so emotionally difficult for them, that they will find it a less bruising experience because they've got some pre-existing understanding before they go into the meeting.
And I think all of those points are really good points. And I had a very bad experience at the beginning of lockdown when I was counsel in a mediation. And this really relates to the tech and how important it is to get that to work, where the mediator put me in the wrong room. And we all stared at each other in complete horror for a bit. Now, fortunately, it was me. I was counsel. So in a sense, I knew the counsel on the other side. It was fine. But if it had been one of the clients, that would have been really difficult. So it's really important, the prep in terms of tech, making it work. One of the things that comes up in every mediation is whether or not to have a plenary session. And when I was trained as a mediator, I was trained that really, it was very important to have that plenary session. As I've got more experience, it has seemed to me that in most cases, a plenary session, particularly in the sort of family dispute we deal with, can be highly counterproductive. And it can take the mediation back hours because somebody has said something that is unfortunate and has upset everybody. And I have vivid recollections of a mediation I was in many years ago when we handed over some without prejudice witness statements, and counsel on the other side tore them up or tried to tear them up. It's actually quite difficult to do that. Upset absolutely everybody, actually gave some of us some amusement. But it can take things back. But there are situations where a plenary session can be quite useful. I sometimes think if charities are involved in a dispute, sometimes seeing the face of the charity, they're often very good, the legacy officers, at giving, pouring oil on troubled waters. So I have occasionally had a plenary session remotely. It has to be handled very carefully. It's more difficult to chair than to do so in real life. And so I've only really done it when both parties have really wanted it. But I'm interested to know, Miranda, what's your experience of whether parties have tended to want this in a remote mediation?
I think the problem is that even in a physical mediation, as I'm going to call it, it's now more honoured in the breach than it is in the observance, for the reasons really that we have identified. I think there is a sadness in a sense about that, because in theory, part of the mediation process is the concept of being able to listen to how the other side put their case, even if it's something you don't want to hear. And you forfeit that entirely in many ways if you don't have the plenary session that has 3 or 4 minutes on these are our 3 major points which we would always be asking the other room to think about. And so I think that's unfortunate, but I think managing it within the concept of us all staring at one another on the screen now, as it were, could be actually very unfortunate. And also you spent quite a lot of time persuading the lay individuals that they can be absolutely safe, as it were, in their breakout room. And I think the idea that in a sense they can come out of their breakout room and be exposed, it is possibly something that's, one has to be extra sensitive about at this juncture. So I wouldn't be undertaking that unless, as you say, you've got perhaps professional individuals involved. And I think even where people have told me that relationships are cordial, there sometimes is a perception by one party that they're cordial and the other party is saying, absolutely, I don't want to have anything to do with it with the other side during the course of the day, because we've got to get through this and out the other side before I can even contemplate that. So I think it's not advantageous for the majority of the time. And perhaps we could come back to, though, the use of the lawyer's room, perhaps after Barbara's talked a little bit.
Yeah. Barbara, what's your view about plenaries?
Very much the same as yours. I used to be reflexively pro, for the reasons Miranda said, but increasingly, I go with the parties. If they don't want one, I will certainly never impose one, and I'll never impose one on anybody. And even when they do happen, I've got my own ground rules, which again, everybody who's mediated with me will know, which is, frankly, the fewer barristers around, the better, speaking as a barrister. I simply do not allow barristers to grandstand, or any lawyers to grandstand at an opening session. I prefer them not to speak at all, other than to say good morning and introduce themselves, put a face to a name. But if they do, absolutely no pompous speeches, no cross-examination, nothing like that. I only want, maybe they're platitudes, but sometimes people need to hear platitudes. The other thing I was just going to say about, I think we'll come on to lawyers' rooms, but I'm pro having a lawyer's room and having a lawyer's meeting, which again is certainly in my inheritance out in estates work is pretty much standard. I like the lawyers just to meet because, after all, they're collaborators, there's no personal animus between them, and often there are things about mutual assumptions and valuations and things to discuss. One of the positive, unequivocal, better things about virtual mediation is you never have a situation, which it seems extraordinary that, grown adults should have to behave like primary school teachers chaperoning little children to the loo, oh, can I go out in the corridor, or are they going to be there? You don't have to worry about that with virtual mediation, so that's a blessing.
Yes. Yes, lawyers meeting is useful, and particularly if you have issues that need to be thrashed out, like the size of the estate or agreement on valuations. And in general, I find that lawyers behave rather better remotely than they tend to in person, and you don't have to sort of chair quite so rigorously as you would in real life. But what's your view, Miranda? You're obviously a fan of the lawyer's room.
Yes, no, I definitely am. I think one has to be careful about the fact that it's not regarded by the lay parties as a conspiracy of lawyers. In a sense, and you have to make it very clear that they're going because, for example, there is a point of principle that everybody wants to discuss. And perhaps that might just be because I just wanted to pick up on, as you said, about the preparation for the tax. One thing I just wanted to pick up on about perhaps a topic that might need to be discussed in a lawyer's room is perhaps sort of in an Inheritance Act claim, for example, the use of Duxbury or the use of Ogden, for example. And I think one of the things that's difficult is, in a sense, having that clash without there being prep in advance by everybody. And so in particular, because of the type of people that we're often dealing with, we might be dealing with the elderly. So anybody over 74, the Duxbury tables, you're not going to live long enough in order to see the stock market give you your wonderful rate of return. And that is even said, it's one of the areas where that's absolutely now explained in at a glance. And correspondingly, this use whereby, annoyingly, they put in this full state pension in any calculation, so that if you're looking at an 80-year-old and you want to give her, you think, £10,000, it's only to give her £25,000. And in fact, in the Duxbury tables, and that's because 9 of that £1,000 come from the state benefit area. And just occasionally, if one side is needing to explain that to the other side, or they're talking about multipliers, multiplicans, etc., the lawyers actually meeting to be able to go back and say, well, I've heard what the other person says and report back, is a valuable opportunity to keep, as Barbara says, the concept of collaboration, even though they have very marked differences about what the outcome should be as a result of that collaboration during the day.
Yes, and that can apply, I think, as well, I would say, in relation to tax issues, whether they can be agreed or there can be a brainstorming session.
Yes.
Costs, it's often easier for the costs information to be swapped in a lawyer's meeting.
Yes.
And I think that's absolutely right. There's a lot of use for that. Going back to some practical matters now, one of the things I found very disconcerting when I did my first remote mediation, which was actually as counsel very, very shortly after lockdown, as opposed to a mediator, was the fact that the mediator would suddenly appear in the room. It was a Harry Potter style disapparition. And suddenly you would find you were discussing some really quite seriously privileged material, only to find that the mediator had arrived. And so when I did my first online mediation as a mediator, I decided that I was going to email the parties before I entered the room. In other mediations since, I've set up WhatsApp groups. I know Zoom has a doorbell function. I've never been able to find that, I have to say. And also you can broadcast that you're coming into a room, but then it lets, of course, the other parties know that you're coming in. What do you two do to stop the Harry Potter effect?
Well, this is my only piece of Christmas cheer, and I have to confess that, in fact, I got that from another mediator, as opposed to it being a wholly independent light bulb moment. That does cover quite successfully the moment of, as it were, privileged discussion that nobody wants you to be party to. I do tend to use the broadcast function. There may be sensitive times when you don't do that. I think the other time, on occasions, it also reassures the other parties that you are still working and you haven't just disappeared into the ether yourself. But there are sensitive occasions upon which you don't want everybody to know that actually you have been sitting outside knocking on the door for half an hour and they haven't let you in. So I think it's just it's the open all methods of communication. And of course, then the difficulty is that how far you want to be repelled as a mediator, because it may be that part of your job is to be knocking on the door with some regularity to see what progress is or isn't being made.
Yes, yes. I think it's quite important to use the warning as a "I'm coming in" as opposed to "Can I come in?"
Yes.
And Barbara, what about you? What do you do?
Similar. I mean, I think it is important because, you know, it is a potential disadvantage that you are invisible. You're in a virtual corridor in your own host's space. People don't know what you're doing, what, you know, who you're with, what attention you're giving their affairs. And so I do like to, I mean, I tend to email quite regular updates, and also at the beginning of the day I'll say, well, look, I think I'm going to be spending the next 3/4 of an hour, half an hour, whatever, with this group of people. Because remember, not all mediations are only two parties. I've done at least one multi-party, where obviously one's time, at any given time, you're not with four parties if there are 5 of them. So I do use email pretty extensively, just to try and map out progress. And often I have the parties emailing me saying, we're ready for you, or, you know, so I try to manage it. I try to make it clear that I am, to the extent that I have the power to manage people's time, which is, I think, part of the job, that I am consciously doing that and not just letting things run. Again, it's difficult. People whenever I do say, well, I think I'll be half an hour with them, it's always twice that. You know, what am I going to learn? I've done over
the fascinating thing is
I always underestimate that time.
And don't you think also what remains endlessly fascinating is that the time that people take to make a decision is actually no indication at all of whether or not what they're going to come up with is unreasonable or reasonable.
Which leads me nicely into my next question, actually, because one of the difficulties for any mediator is getting somebody to blink first. Making that first offer and eliciting that first offer, I think, is the most challenging part of the day. Now, it may be obvious that somebody's got to make the first offer because, for example, they're a claimant in a 1975 Act claim, there have been no previous negotiations, they haven't perhaps set out their stall, and they've got to move first. Or alternatively, it may well be there's been a whole host of negotiations and it's clearly one party's turn to respond to the last offer. But that's not always the case. It may be a very different sort of case. It may be a probate case, professional negligence, undue influence, where it's not obvious who should go first. My two tricks for eliciting that first offer, and they're not really tricks at all, but just sort of ways of trying to persuade people to do it, are to say, first of all, it gives you the opportunity to take control of the structure of the offer. So if you make the first offer, it gives you a bit of control over the process, because it is likely, not bound to happen, but likely that the other side will reflect back on the offer that's been made. And the second point, I think, that I always make is that actually in a long mediation, often people can't remember who made the first offer. And it isn't a sign of weakness to do it, which I think is what other people fear. But can I ask, Miranda, what do you do?
Well, I think the answer is also this isn't just the online mediation position, is it? And I think there's a bit of an issue perhaps that is developing, that almost the vortex of mediation leads people being sucked into the mediation but going, oh, we perhaps won't set out what our position, we won't make any offer before. And I think that's a bit of a problem that we need to grapple with. I think sometimes you can tell in terms of state of preparedness as to whether or not there is one party who is in a probate dispute more able to vocalize where they have got to. And therefore, the reality is that you will be undoubtedly encouraging them, saying, well, you will then get you will, as you rightly say, get a reaction. May not be a reaction that you want, but what it is I think Barbara's got a very wonderful phrase, which is about engagement. And it is an indication, even if it's felt almost that it is this problem about whether it's incendiary because it's so low or so high, that the commitment to the process is immediately questioned in the other room. But it does get, as you say, the sort of tracks where you might then make progress if somebody comes forward. And I think if you've been able to meet with your client before, you jolly well hope that you don't need the first 4 hours of the mediation to determine what is going to be your first offer. And that would really be a plea, because I think otherwise You know, if you get to lunch and nobody has actually committed themselves, that is a terrible indictment on the use of the first 4 hours of your mediation, really.
What about you, Barbara?
Two things really. One, and this links to what I was saying about thinking time. It's a huge psychological burden on the client to make any offer, and particularly the first offer in the process of negotiation. Again, for lawyers, we do that. It's part of our work, and it's not our case, in the sense it's not being our personal affairs. But it's extremely hard for them. And I think acknowledging that, and I quite often openly acknowledge it and say how very difficult it is, because it involves a recognition that realistically, yes, this progress, this mediation is without prejudice, you're not bound by anything, but you know very well you cannot go up from your first offer. And also that it's relatively unlikely, I know Penny's got a different experience, it's relatively unlikely that your first offer will be accepted. And that's where this concept of, I often talk about, the zone of realistic engagement. I mean, you start in a case where there have been no pre-mediation offers of any kind at all, whether informal or Part 36 or anywhere in between. Take a case where there have been no pre-mediation offers at all. Your parameters are basically 0 and infinity, the very opposite of compromise. You can't get further away from a compromise. Well, I suppose the only way you can be further away from a compromise is not in the same room. So I do always start by asking, by thanking people and saying they have made progress by agreeing to mediate, because it is progress. But you want to get away from 0 to infinity, and you want to narrow your parameters towards compromise. But there's a zone where you're not on 0 to infinity, whether it's a pre-mediation offer or a first offer and response made at mediation, where you know it is not going to settle in that region. It's a zone that's unacceptable to the other side. And sometimes, you know, I've had every variety of boomerang response, as it were, to first proposals along those lines. And what I'm always working towards is getting people into the zone of realistic engagement, the zone where it is, you have some confidence, some reasonable confidence, whether on that day or not that long afterwards, it is going to settle within that zone. And you sort of know it when you're there. But I think it's certainly useful for me to analyse it and articulate it in that way.
Yes, I think that's absolutely right. That really struck a chord with me. That's,
sorry, frozen.
You get to know the point at which I always put it, you're in the ballpark. You know that actually that it's feasible. And I think there are differing views about whether it's a good idea to support any offer that's made with some reasoning. Now, I really like the first offer at the very least, and often the subsequent offers to a point, to have some reasoning to support them, not just to be a figure, but to say, you know, I think your Inheritance Act claim is worth this much because I've been through your budget, and these are the things I agree with, these are the things I don't agree with, and so on. Or if it's, say, a professional negligence case, I think you've got a 50% chance of success. This is what your damages would be. This is what I'm offering. Because it seems to me it gives the other side something to engage with. But what do you think, Miranda? Do you like to have fully reasoned offers?
I think undoubtedly, I think it has a number of roles. A supported offer. One, because it's very important that the lay party on the other side, who for the most of the occasion, will only hear the headline figure. And in a sense, how the other side have arrived at that headline figure, therefore becomes actually an incredibly important part of allowing them to move away from the fact that the headline figure just sounds too much. What are the building blocks? What could you go back in those circumstances and say, we can knock out that building block, but I can understand that there may well be, an award may well be that amount for this reason. So I think it's incredibly important. I also think it absolutely facilitates the mediator's job, because it helps us not look in any shape or form, when we're doing reality testing, partisan, as it were, because we can be saying these are the reasons that the other side have advanced. I think these are reasons that we need to discuss in that room. And so I think it's of enormous importance. I mean, as one rightly says, as you get into a very close element of negotiation. You're of course always in a range, and at that point in time I think the mixture is between horse trading and potentially we were talking about what's the value of the horse, in the sense of are we actually rather in a position whereby, oh, can I just explain that there's somebody in the rear of my room who I would like to leave the room very shortly because this is my private breakout room. Thank you very much. And in those circumstances, what you can see is the importance, I think, of people understanding how people are approaching it. So I would be a wholehearted supporter until you get down to the horse trading, where we've talked about the value of the horse and whether we're into salami trading, because actually we need to settle the case.
Barbara.
Pretty similar, really. And I think, again, there's a sharp difference between the stage of the mediation where you are articulating reasons in a very careful way, and where, and again, something I'll quite often articulate is you have been through, you know, you've examined as far as you can today the legal merits, the quality of the evidence, and so on. I think it's important at the beginning because for all the reasons Miranda said, but also for my own perceptions, which I have to keep to myself, of where I think the weakness of analysis, where the litigation is about risk assessment, and that's partly subjective, but there's an objective element to it too. And it helps me to form a view of where I think their subjective risk assessment is wrong. Let's move away from Inheritance Act cases to probate cases. Pure contested probate has a binary outcome. Either you win or you lose. Consequences predetermined by the sequence of and contents of previous wills or intestacy. There may be a concurrent or a consequential Inheritance Act claim or an estoppel claim. Let's just think of a single probate claim. It is all or nothing. One side is going to win and one side is going to lose in an entirely undifferentiated manner. One side is right, one side is overconfident, and one side is underconfident. And I mean, I quite often have the conversation about one of you is wrong. I don't then proceed to bluntly shred every single strand in their argument, but it's getting people to do the work for themselves. And I think that's a very big part of being a mediator, is structuring conversations, but also structuring people's thoughts. You know, and that is work that needs to be done.
Yes.
And if you ask for reasons, well, it helps you and it helps them to do that work.
Yeah.
Yes, I think that's absolutely right. And actually being able to probe, get the balance between probing the merits of somebody's case, you know, what happens if you lose, what's going to be your worst day in court, but also, well, what about this evidence? Isn't this a bit of a problem? How are you going to deal with it? Just asking questions without undermining the lawyers. I think that there's a particular balance that has to be struck so that the lawyers who are giving the advice aren't undermined, particularly if they take a very different view from the one you've taken. You almost have to probe it without revealing your own view, which is something I think that is a very different skill. So we've elicited our first offer. But it's one that the other side are there are howls of outrage when one apparates into the room, and they say, well, we don't even want to make a counter offer. We can't possibly take that offer seriously. It's negotiating against ourselves because it's so ridiculous. How do you deal with that? I mean, I think that's one of the hardest bits of the mediation, often actually keeping, persuading someone, making the counter offer is really worthwhile because it's going to keep the process going. You need to keep the process going. And if they just ignore that offer, make their own first offer. But what do you do? What do you do, Miranda?
Yes, I think you're absolutely right about the idea of there is a very deeply embedded resistance to negotiating against yourself. And in a sense, the problem is if you've started with, your two offers, as Barbara says, at the opposite ends of the spectrum, and everybody then goes, oh, we don't think there's any serious engagement. The way to get the serious engagement is actually to say, well, the last, you've got to respond, you have to respond. And it's just because it will elicit, it will put them under pressure. it will put the other side under pressure if you continue with the process, which then is a response to another offer. So I think it is, but you can find, I think, that when people are, people do fight quite hard to say that is an unreasonable offer and I'm not in those circumstances going to negotiate against myself as they perceive it to be.
Yes.
Yeah.
Barbara, what about you? How do you approach that sort of reaction to an offer?
I agree. I mean, I talk about naught to infinity and narrowing parameters in the zone of reasonable engagement, and I just keep talking about it until they'll say anything to make me go away.
Yeah.
Well, I think the idea of where, as the mediator wearing the parties down, there is something to be said for that. And I think that's right. I think it is a question of trying to say, look, you've paid a lot of money to be here today. You've done all this prep. You're here. This is your best chance of trying to settle it. Yes. Why would you walk away from it? And I think that's absolutely right. Of course, it can be more difficult in a remote mediation to keep people in the mediation. I have a very clear recollection of mediating at the IDRC in Fleet Street, which seems like a distant memory now. Mm-hmm. And I was just about to take an offer I thought would be acceptable into the other room when I saw them all walking to the lift. Mm. And I chased them down Fleet Street. I mean, it was a real wake-up call as to how I needed to get a bit fitter, but brought them back because actually, you know that there's an offer. Now, I couldn't have done that remotely because people can just simply go. You can't physically get them back. And I always say to people, look, please tell me if you're thinking of ending this, because it may well be you're closer than you think. We've looked at the not taking the offer seriously. One of the things that often can cause at least a blip in the mediation process is to find that you've got a beautifully negotiated settlement. You're delighted the parties have come together, and then somebody raises the chattels or the ashes. And I'm using those as examples, but things that perhaps in the grand scheme of the £5 million settlement that you've just seen negotiated may not seem very important, but are of course crucially important to the parties involved. How do you deal with that? Now, I know from my perspective, I've had my fingers burnt often enough with that coming up right at the end, often after the deal's been done and the drafting's started, to actually ask people to think about it quite early on. And if there are any issues like that, to bring them out in the first offers so that, they are something in everybody's mind. But what do you do? Miranda, what do you do to deal with that?
I think you're right. I think we use, we talk about the chattels and the ashes, but we have to remember that the ashes are the remains of the individual about whose estate has caused problems within the family. And you might be looking at several years because, for example, father's ashes are in the garage and it's mother who's now died, and are they ever going to be put back together? I've had that as a problem, so we had to talk about other people's ashes that weren't part of the mediation, and we couldn't have done that at 11 o'clock at night, whereas we did it by raising it in the morning. And I think, again, ideally, if you can have done, it doesn't need to be a comprehensive chattels, but again, when we're talking about chattels, we're quite often talking about somebody's childhood, in a sense, that's being potentially thrown to the bottom of the garden or gone to a charity shop. So I think that's very important to, in a perhaps not a confrontational way, but to say early on, well, I can see that you perhaps haven't dealt with these in correspondence conclusively yet. And so during the day, if somebody's got ideas, I could be taking them in as they go along. And the important thing perhaps is to get that somebody shouldn't be so dictatorial as to say, well, if I don't have the 30 items on this list, I'm pressing the link and I'm leaving. But just to make sure under there, it's still, it's raised as something that we're going to have to deal with in as sensitive a way as possible. And I think the whole issue of the use of ashes in circumstances where church services and things are quite often a thing of the past gives us all extraordinary ideas about how people might deal with those things. And I think Barbara has experience potentially of how creative one might need to be in relation to that.
Yes, Barbara, what's your experience?
Well, I was just going to say ashes is one thing, and one of the very few pieces of dinner party legal advice I give to you, which is not a very tasteful subject for dinner parties, for God's sake, don't bury your ancestor in the back garden if they want to do that. Dissuade them strongly. I've certainly I can't remember now whether as a mediator or as an advocate, an advisor, in at least one case where there was an ancestor buried in the garden. Endless problems.
Yeah.
But to be serious, I mean, once you bring your personality to a mediation inevitably, and your whatever skills and experience you have, partly because a certain amount of downtime is spent chatting, so people get to know you conversationally a bit. But it's important, I think, obviously it's important not to in any way impose or normalize one's own. My own view, I don't mind sharing this with this audience, is I'm utterly matter of fact about it. When I'm dead, and I don't care what happens to my ashes, but I know that isn't what everybody thinks. And what seems to be an obvious practical solution is division. And Miranda and Penny and I were chatting about this when we were setting up this session, and both of them mentioned experiences of people who've found even the thought of dividing ashes terribly insensitive and intrusive. So it's an absolute area to tread carefully. And all I can say is get people to think about it in their own time.
And I think quite often what you find is that actually the problem is that because there's been a ruction in relation to the inheritance, the whole aspect of perhaps what is left behind in terms of even a physical place that people may or may not observe becomes the more important in the absence of being able to have the discussion with the deceased as to quite why we were in the mess we're in and in mediation.
Yes, and I think that those are all very good points. It all has to be handled sensitively. You may be thinking to yourself privately, oh, for goodness sake, what is the row over the pheasant loo brush holder, which was something I had in one of my mediations, you know, why are we setting up a trust for the Winnie the Pooh figurine? Those are true stories, I promise you. But at the end of the day, these are things that don't matter to you. But they matter to somebody. They matter enormously to somebody. So one has to have patience and sensitivity, I think, in dealing with that. Okay, so we've got our agreement, we've got our deal, which is always a wonderful moment for a mediator in a mediation, I always think. It's lovely going into somebody's room and saying, you know, you've got a deal. And then the drafting happens. Now, hopefully, and I think this is really important with online mediations, it's really important to have drafted something, I think, in advance if you possibly can. There are cases where it's impossible because you just have no idea where it's going to go. But in most cases, you can have that Tomlin order drafted. You can have those heads of terms up and running with the blanks to fill in at the end of the mediation. And it saves so much time. It's worth every penny of the preparation. But the question is, do you keep the mediator on? Now, I had a recent experience where one of the parties was very keen that I shouldn't hang around, even though I'd offered, as it was a remote mediation, just to come back to help with any difficulties over the drafting. And, you know, I wasn't proposing to take any further part in the mediation. But I know that the drafting there did take a long time. And my experience as a mediator is the mediator can often be really helpful at actually trying to mediate the disputes on the drafting. And I don't know, Miranda, do you always prefer to hang around?
Oh, absolutely, indubitably. I think it's a very big mistake. I do think that everybody is perhaps tireder at the end of a virtual mediation than, funnily enough, even though they haven't had the travel time, from the point of view of the lawyer's concentration, etc. And I think people can be quite scratchy, and you need, and you know, you're dealing then with people's preferences for drafting one way or the other, and so you're having to coordinate that, as it were, on the ground by probably we've been using largely drafts that have gone by way of exchange on email with track changes and everybody, but at that point in time, you are able to pull everybody into the lawyer's room saying, look, this is where we've got to on the track changes. Where is there a problem? And actually, I do think that you tend to, in those circumstances, help everybody through that important stage, let alone the process of the whole thing blowing up potentially in your face without you. So the reality is I absolutely think it's vital that you remain. And I also think that you are, as you rightly say, you're able then also though to continue the diplomacy perhaps that we've talked about chattels, ashes, directly, perhaps if you've got counsel drafting and you've got solicitors who are, you know, on number 20 of the list, and that's the one that's going to be that breaks the camel's back because you can't have the pheasant loo roll holder. In those circumstances, you're working on those lesser things also, and then you're also making sure that what's everybody's prep at the other end for, does the printer work, does the scanner work, is there going to be an electronic signature? Is it going to be done on somebody's behalf? So I say I think we're worth it in those circumstances.
And Barbara, I think you've got some strong views about actually how it might work better, the drafting process on remote mediation.
That's certainly my experience. And I used to say at face-to-face mediation that it was never over until a fat mediator had eaten the last digestive biscuit. Now, I completely disclaim being a fat mediator, or indeed eating all the biscuits. But the point is, I stay till the end. And I mean, yeah, I usually write off some of my time where I've not actually been actively engaged while the party's been drafting. I find managing that side of the process has gone much better in remote mediation for two reasons. One, my time can be used better. For example, somebody will commence drafting and I will say, right, I mean, the particular occasion I'm thinking of, it was about 7 p.m. So, right, I'm stepping away from the screen now. I'm going to go and get something to eat and be away from this room and from the screen. X thinks it's going to take him about 3/4 of an hour. Let's say this time I'm going to come back in. The rest of you, do what you wish to do, treat yourselves as free to go. And I'm walking away from an hour and I'm not charging you for that hour because I genuinely am free to go and catch up with emails or any sort of downtime activity and have something to eat. And of course, I'm still actively thinking about the case, but still. So there's a sort of commercial attraction in it. The other aspect is I've found, look, the setup that I have, I've got access to video stream, bundle, word processing and email on a variety of devices. For circulating drafts, I mean, so many times with physical mediations, and don't get me wrong, I've got a sort of touch of nostalgia for the, I walked past the IDRC a couple of weeks ago. I was walking up Fleet Street and my phone logged onto its Wi-Fi. And how can you be nostalgic for a building like that with its terrible, terrible catering?
I think they weren't planning to move when they had.
I have got a slight nostalgia, but it's access. If you remember, sometimes at a real mediation, oh God, somebody's got to find the key to the floor where the printer is and the code to get into somebody else's work file to activate the printer and then rinse and repeat several times. Everyone has access to their own desktop and their own desktop tech and their own native email, and that just cuts out a lot of stress.
Now I'm going to move to the questions now, because we've had some really good questions and I want to leave time for us all to answer them, albeit that we're going to have to do it fairly sharpish. So I'm going to ask for one-line answers. The first is, what do you think are the merits of synchronous mediation versus asynchronous online mediation?
Right.
So I mean, I actually think it's quite possible because, of course, you don't actually need to have everybody there at the same time. I haven't tried it. I can see it might work if you had an offshore mediation. I can see that might, it might, or parties in different jurisdictions, that might work. But I actually like the pressure that asynchronous mediation puts on people, that feeling you're all there and you're trying to do a deal.
Yeah.
What do you think? Sorry, that wasn't a one-line answer, but that's my prerogative as chair.
Yeah, I think perhaps time differences and issues, if you perhaps have an aspect that might be particularly a legal point that you need to deal with, then that might be something that you think might work on having that differential between them. But I'm a great believer in everybody, if you have however many people, 10 people concentrating on a problem at the same time, with the exception of the Brexit negotiations, that actually produces usually some element of consensus.
Barbara?
Haven't tried it, open to it, particularly perhaps staggered start times. If you can ditch the plenary, why not have a staggered start time? And I know Beverly Rogers, who's both friend and professional contact, she starting her mediations earlier, which if you're a non-morning person, that's quite daunting. But I might just acclimatize myself to it.
Yes, and can I say I've had a mediation starting at 8:30, and that was fine. 8:30, and that worked very well because we were done by 6. So, but anyway, it depends on how it works with the parties. So, has anybody got any experience of court of protection mediations? I know I haven't, but I'm aware that they are being very firmly promoted, and I would have thought they'd work very well.
Yeah.
Either of you?
I think Barbara is the person with the most experience in that area.
I've done a couple, not recently, but in the last 5 years. One was, it was a live application for a gratuitous care payment, and there was that in a collateral dispute. And there was another one, I think, where an incoming professional deputy had been given permission by the Court of Protection to sue outgoing non-professionals, and there was more than one non-professional, and they were separately represented because there were different alleged liability bases. Risks of costs becoming disproportionate were enormous. We got a very satisfactory compromise out of that.
In the light of the pressure on the Court of Protection, Barbara, you would have thought that there perhaps would have been more than there actually are coming through the door at this juncture. So
I confidently.
Scheme. I'm not part of that. It was more for, I think, quite straightforward things, and I think a number of the junior members of chambers have been involved. But I couldn't give you an up-to-date status report of it.
What do the speakers, and again, we really must do one-line answers now, what do they think about position statements? I think they're really helpful. To me, they're for the mediator, and they're to give an overview, and they're really, really helpful. What about you, Miranda?
Well, the same thing, but in particular, they always provide a reference point through the day for you to go back to do any reality testing, in a sense, to say, well, that's raised on the face of it, and is something we're going to have to perhaps grapple with in the course of our discussions about what the response might be.
Yes, and Barbara?
Yeah, and I don't want some long ramble, just who's who, what's the case about, where are the key documents, have there been any pre-mediation offers? That's it.
Yeah, exactly, that's perfect. This is a good one. If the party is opposed to division of the ashes, what other compromises have been reached?
Well, I think it is to find a place that the person enjoyed. But it may be that it's 2 different places. I think I had one lady who was a frustrated racing driver as an amateur, and we thought that might provide one particular racetrack might provide a suitable place. Something that is perhaps a bit more imaginative and wacky might at least generate some sort of ideas from the lay clients about of the individuals who knew the person best.
Barbara, any other answers on this? No, I have.
Sky burial is the best alternative.
I haven't. And we've got one more question, which is a really good one. How do you address negotiations and a proposed settlement when one of the parties is a minor? Well, the answer is the court has to approve it. And so the best you can do is come to a settlement. And if you've got the minors' counsel or solicitor there, and it's really helpful to have them at any mediation, is to come to a settlement that they think they can recommend to the court.
But you quite often find, don't you, that there is a problem because that they're not there.
Mm.
And so what you have been, because they were a minor player, but still important. And so you won't have a concluded agreement until you've got the approval of the court. So you need a timetable for getting that, and who's going to pay to get the approval.
We've reached the end of our time now. Thank you very much, everybody, for joining us today. When we did the last webinar on mediation, we also discussed other forms of ADR. Please don't forget those, early neutral evaluation and FDR. If you'd like to look at our previous webinar, it's on our website under the news section, and also we have, rather unbelievably for Five Stone Building, as a YouTube channel, although I'm sure it won't be amusing as some of the cat ones. Anyway, goodbye to everybody, and season's greetings to everybody, and thank you for joining us. Goodbye.